Good day. I'm Chilton Varner, the president of the Supreme Court Historical Society. It's my honor and pleasure today to welcome you to this virtual lecture delivered by Marlene Trestman, who is one of our most stalwart friends and supporters. The Society continues to pivot and perform, notwithstanding that the pandemic seems to be stubbornly unwilling to come to a complete stop. We're hopeful that we will be back to in-person events in the near future. We recognize, however, the value of having these virtual lectures that are readily accessible to all of our members across the country and can also be preserved permanently on the Society's website. In short, we've been able to reach a broader audience than we have had before. So even if we are back in the Supreme Court building come fall, we're likely to continue some version of our virtual lectures because we want to build on this larger audience that we've been able to reach during the pandemic. Now, today's program will feature a lecture by Marlene Trestman about Bessie Margolin. For those of you for whom that name doesn't spring readily to mind, Bessie Margolin was essentially the New Deal's fair labor lawyer. Ms. Trestman's going to talk for about 30 minutes. She will then stop and take questions, remarks, and the like from members of our audience. If you have such communications, please convey them to us. It's important to us to know what you need to know. And if you will send those communications via the Q&A feature of your Zoom connection, Jim Duff, the Society's executive director, will be selecting questions for our lecturer, as many as we can, given our time constraints. Now, a bit about our speaker. Marlene Trestman is a lawyer. She's also the author of a book entitled Fair Labor Lawyer, The Remarkable Life of New Deal attorney and Supreme Court advocate, Bessie Margolin. Ms. Trestman is currently working on a second book entitled The History of the New Orleans Jewish Orphans Home, 1855 through 1946. For the last decade of her 30-year career in the Maryland Attorney's General Office, from which she retired in 2013, Ms. Trestman served as a special assistant to the Attorney General and was responsible for enforcing consumer protection laws governing the marketing of tobacco and alcohol and internet safety. In recognition of her considerable contributions, Ms. Trestman has twice received the Attorney General's Exceptional Service Award. A Phi Beta Kappa graduate and a member of the Board of Trustees of Goucher College in Maryland, Ms. Trestman earned her law degree from George Washington University and her MBA from Loyola University of Maryland's Selinger School, where she has also taught law. Ms. Trestman has received recognition and financing through research grants and fellowships from the National Endowment for the Humanities, the Hadassah Brandeis Institute, and the American Jewish Archives. A busy lady, to be sure. She has been a recipient of our Society's own Hughes Gossett Literary Award for an earlier article about, you guessed it, Bessie Margolin. Today, we continue that conversation. I'm delighted to welcome Ms. Trestman to the Society's virtual platform, and I'm delighted to welcome our audience for what I promise will be an interesting and informative afternoon. Thanks.
Thank you, Chilton, for that wonderful introduction. And while I bungle here to share my screen, as I thought I might, even though I practiced this, I'm going to take a minute to thank the Historical Society for making this book possible, and indeed making it possible for me to write the article about Bessie Margolin. I received enormous assistance from Claire Cushman, who is now, I believe, the resident historian of the Society, and she was instrumental in allowing me to have this program go forward. So I'm hoping, I'm having trouble now sharing the screen. Oh goodness, I see it. I wish I could get Jennifer to help me here. It worked in our rehearsal.
It did work in the rehearsal, and you still have the co-host function, so you should be able to do this. There we go.
You got it. Okay, there we go. Oh, goodness. Terrific. All right. And again, thank you to the Historical Society. I know Bessie would be very pleased for you all to be learning and getting introduced to her today. Through a life that spanned the 20th century, 1909 to 1996, Bessie Margolin made her mark on the biggest issues of her day. She defended the constitutionality of FDR's New Deal. She drafted rules for the Nazi war crimes trials. And for more than 3 decades, she championed the Fair Labor Standards Act, which ultimately included the Equal Pay Act, which led her to become a founder of NOW. She presented 24 arguments at the Supreme Court, one of only 3 women to do so in the entire 20th century, and she prevailed in cases associated with 21 of those arguments. By my count, and I've spent some time doing this, to this day, Margolin remains one of only 7 women to argue at the Supreme Court 24 or more times. She began her legal career in 1930, when only 2% of America's lawyers were women. She served in the federal government under 6 presidents from FDR to Nixon and 9 labor secretaries, beginning with Frances Perkins. She received every award the Labor Department offered, and by 1963 was promoted to the department's top non-political legal position. She was a striking woman of cultivated Southern charm who turned heads when she entered a courtroom. In short, before there was the notorious RBG, there was the audacious Bessie Margolin. But after she retired in 1972, she seemed to fade from the public record. So it's not hard to understand why she deserves to be rescued from obscurity, but I'd like to start by telling you how I came to the task. In the fall of 1974, I was a freshman at Goucher College in Baltimore, far from my home in New Orleans. My high school guidance counselor had written Margolin, a distinguished alumna from the Isidore Newman class of 1925, the letter of introduction shown here. Through college, law school, and into my legal career, I got to know Bessie Margolin. She was the first female lawyer I ever met, and we were connected by common childhood experiences. Bessie and I were both wards of the same Southern Jewish Children's Welfare Agency, which educated both of us at Newman School a half-century apart. Bessie Margolin personified excellence in the law and in public service at a time when women attorneys were discouraged, if not outright prevented, from pursuing opportunities available to men. While protecting the rights of millions of American workers, she also advanced the careers of countless lawyers and other employees, many of whom sought out her prestigious and, yes, demanding tutelage. I'll share her journey from beneficiary of social justice to its powerful advocate. Bessie was born in 1909 in Brooklyn, New York. She was the first American-born child of Russian Jewish immigrants. From there, to escape New York's tough and crowded conditions, Bessie's family made its way to Memphis. About a year after giving birth to a third child, Bessie's mother died, leaving Bessie's father alone to care for his 3 young children. The Margolins' plight attracted the attention of a rabbi who petitioned the Jewish orphans' home in New Orleans to accept the children as so-called half-orphans. So in 1913, the orphanage admitted Bessie at age 4 and her siblings. The home, as it was known, sat prominently on St. Charles Avenue near the stately mansions of New Orleans' most prosperous citizens. In the home, Bessie grew up with more than 150 other orphans and half-orphans from throughout the Deep South. Its trustees were not content to provide them with mere subsistence. Instead, the home groomed Bessie as an all-American girl who shed honor on the local Jewish community and reflected the values and culture of her prosperous benefactors. In addition to a reformed Jewish education, the home provided Bessie with a robust secular education at the Isidore Newman School, the Isidore Newman Manual Training School, where the cutting-edge curriculum emphasized home economics and woodworking, as well as rigorous academics. The home built this unique school to educate its wards first, but was open, regardless of religion, to other children, albeit then only white children, whose parents paid tuition. Newman quickly became what it remains today, one of the South's finest college prep schools. Bessie excelled in every subject. She graduated from Newman in 1925 as a 16-year-old leader who was comfortable in a co-ed setting, competing, succeeding, and winning respect. Besides leading the debate club and the Girls' Student Council, Bessie was valedictorian and won a coveted scholarship to Newcomb College, which was then Tulane's coordinate college for women. She spent 2 years at Newcomb, ranking among the top 10 in her class, but the audacious Bessie wanted more. She decided to attend law school, something no other girl from the orphanage had done. As Tulane Law School's only woman at the time, Bessie felt isolated and self-conscious. When a professor lectured about a case involving an accident in a men's bathroom, no one in the class wanted to discuss the facts of the case. They were embarrassed to use the word toilet in mixed company. When one poor fellow finally blurted out washroom, they all sighed with relief. In June 1930, at age 21, Bessie completed her liberal arts and law studies with honors in only 5 years. She graduated second in her law school class and was an editor of the Law Review. At the height of the Depression, jobs were scarce, especially for a Jewish woman lawyer. But Tulane Law School's dean urged Yale Law School's dean to hire Bessie as a research assistant. In New Haven, Bessie impressed her boss, as well as a wildly popular young Yale professor, William O. Douglas, the future Supreme Court Justice. Having earned their respect, Bessie became the first woman awarded Yale's prestigious Sterling Fellowship for Graduate Studies. With her Yale doctorate, Bessie moved to Washington, D.C. for a new opportunity. She applied for a job at the Tennessee Valley Authority, which Congress had just created to realize FDR's New Deal vision of supplying electricity to the Valley's impoverished residents. Her Yale boss wrote what the TVA apparently needed to hear to hire a woman lawyer. That Bessie was intent on a legal career, quote, as a primary objective from which she would not be deflected by consideration of marriage, end quote. Bessie thus began her government career with a pledge that she would be married to her job instead of a man. Fearing TVA's competition, private utility companies hurled charges of socialism that quickly turned into lawsuits. To direct the legal defense of this New Deal cornerstone, TVA hired James Lawrence Fly, a Harvard Law graduate and experienced trial lawyer from the Justice Department. Fly wisely made Bessie a key member of his brilliant legal team and its only woman. She researched, prepared witnesses, and materially shaped the briefs in two landmark Supreme Court cases that upheld TVA and its programs, Ashwander and Tennessee Electric Power Company. In her other TVA work, she negotiated contracts and got courtroom experience, all despite fierce resistance to a woman lawyer from local attorneys, judges, and even witnesses. So how did Bessie feel about her profession? In 1938, she shared her thoughts in her sororities magazine. The law is still too greatly restricted for women, with considerable prejudice against them, she wrote, and offered her sorority sisters this no-nonsense advice. A woman attorney must manage to be accepted and treated as another man, and must be willing to take responsibility, criticism, and hard work in the same spirit as do the men attorneys. She must aim to become one of the men, without, however, becoming masculine or overly aggressive in her approach. It was 1938. Bessie practiced what she preached throughout her career. In March 1939, Bessie joined the Labor Department, where another New Deal program awaited enforcement. The Fair Labor Standards Act of 1938 prohibited child labor and guaranteed minimum wages and overtime, as it does to this day. Bessie was there as every aspect of the new law was tested. During her first few months on the job, her work brought her back home. The New Orleans press loved Bessie's local girl makes good story. One full-length photo, shown here in the middle, captured Bessie in a pose more cheesecake than lawyerly. Why wasn't she married, the press demanded. One reporter recounted Bessie's coy response this way: "I haven't had time for love, but I'm not immune. I'm just uncontaminated." Now, Bessie's remarks merit several notes. First, it was witty, like a line from a Katharine Hepburn movie revealing Bessie's passion for wordsmithery. Second, she seems neither defensive nor self-conscious about being single. And third, it just wasn't true. But given today's time constraints, to find out about Bessie's penchant for passion that prompted several federal investigations and further derailed her chances for a federal judgeship, you're going to have to read the book. The drama of Bessie's personal life never impeded her work. In her early years at the Labor Department, she paid her dues reviewing timesheets in damp warehouses and traveling back roads in her Hudson coupe to interview vegetable packers, and log cutters. She began arguing and winning appeals and started working with the Solicitor General's office on cases headed for the Supreme Court. Bessie's high-quality work earned her recognition. Delighted with a Supreme Court brief she principally wrote, Solicitor General Charles Fahey promised she could argue the next Fair Labor Standards Act case to go to the court. So in March 1945, before Sandra Day and Ruthie Bader reached high school, Margolin became the 25th woman to argue at the Supreme Court. After what must have been a lively argument, Justice Robert Jackson marked the occasion with a thoughtful note, the first of several he wrote to Bessie over the years. "I hope you were satisfied with the way the court argued your first case. I'm sure there would be no dissent from the opinion that you should argue here often." Bessie won that case, establishing the long-standing precedent, until recently, that exceptions to the Fair Labor Standards Act must be narrowly construed. Before the year ended, Bessie argued 4 more times at the Supreme Court and prevailed in 3 of those cases. These and the rest of her many cases that followed all advanced the Act's humanitarian purposes by protecting wage earners to the full extent Congress intended. But when Bessie presented her 4th and 5th arguments at the Supreme Court, Justice Jackson was not on the bench. He was in Nuremberg, Germany, after World War II as the U.S. Chief Prosecutor for Nazi war crimes. This new and exciting legal pursuit attracted Bessie, who in May 1946 went to Nuremberg to help organize what became the American Military Tribunals. For her 6-month tour of duty, the Army's commanding officer acknowledged Bessie's primary role in drafting the rules that governed the war crimes trials of some 200 second-tier Nazis, the judges, the doctors, and the industrialists. In December 1946, Bessie returned to the Labor Department, epitomizing the new post-war ideal of a glamorous career girl succeeding in a man's world of law. She was featured in the January 1948 issue of Glamour, then known as the magazine, quote, for the girl with a job. Times have changed. But Glamour did not interfere with grit. By the time she retired in 1972, Bessie had directed the preparation and review of approximately 750 Supreme Court and other appellate briefs and petitions. Most impressively, Margolin principally briefed and personally argued 174 cases in the Supreme Court and other courts combined, winning an astounding 8 out of every 10 cases she argued. Now, Bessie Margolin was no great orator. She often edited herself as she spoke, making it difficult to read her transcripts. But listening to her is another matter. She engaged the justices who respected her meticulous preparation and encyclopedic knowledge of the law. And she was able to employ humor, something not often done with success at the Supreme Court. In this 1955 audio clip, you'll hear Bessie spar with Justice Felix Frankfurter in Steiner v. Mitchell, where Bessie successfully argued that battery plant workers whose jobs involved contact with toxic chemicals had a right to wages for the time they spent changing their clothes and showering. Although you may not be able to hear everything he's saying, you'll hear Justice Frankfurter's annoyance with Congress for imposing on the courts what he considered to be undue burdens of interpreting the act, an annoyance he frequently redirected at Bessie.
Now, I grant you that that is not something that's ABC, a simple decision to make, but it's no different than many questions of statutory interpretation as to the application of the legal criterion of the statute.
And it would not have been too difficult to put your word into the statute.
What, work day and whistle to whistle?
No, that's what you said.
Well,
That's what you said.
when you try to get 400, you've many times said to me that the court should leave the questions for Congress and not for the court. But after all, Congress has 400 or 500 people that they have to get into agreement on language. And the court has just 9. And which is enough. Well, I'm sure, Mr. Justice Frankfurt, I don't need to tell you that language is not something that is easy to make clear.
And in this next 1960 clip, you'll hear how comfortable she was with the justices, probing her positions and dissecting her arguments. She's just plain having fun with the way Justice Charles Whittaker worded one of his questions.
This offers an opportunity to straighten out the court, and I would like to go on to show the other clear basic areas.
Just a minute, please. May I ask just this question? Do you stand or fall in this case on your answer to the Chief Justice?
What do you mean, do I stand? As I see it, I stand, I don't fall on either. I stand.
Bessie won that case with Justice Whittaker, not surprisingly, providing the lone dissent. As for Justice Frankfurter, despite the banter you heard in the prior clip, Bessie and he enjoyed a cordial relationship outside the courtroom. She certainly got his attention, as evidenced by his private notes to his male law clerk. In one, Frankfurter referred to Bessie's, quote, deft use of her feminine charms, and in another to her, quote, exploitation of her female talents. Was Bessie playing the woman card? If I'd been able to ask her, I think she would have said she was playing the only cards she was dealt. In the early 1960s, Bessie decided to pursue a federal judgeship, and not just any judgeship. Bessie wanted a seat on only one of two federal courts in D.C., a particularly audacious goal given that there were then only two women federal judges in the entire country. With enthusiastic backers from Congress, the Supreme Court, and the Labor Department, Bessie's name was considered by LBJ himself. It's not clear what, if any, role in the decision was played by her affair, the one you'll have to read about in the book, but she also faced other hurdles. One male White House staffer criticized Bessie's fashion-forward appearance as, quote, flamboyant, and another opined, quote, her age, 58, would tend to preclude her from consideration, end quote. By 1968, Bessie had been passed over for 7 federal judicial vacancies on those two courts alone, all filled by men, 5 older than she was. The silver lining from Bessie not getting a judgeship is that she stayed at the Labor Department, where she developed the national strategies and personally argued the first appeals under the Equal Pay Act and, somewhat ironically, the Age Discrimination in Employment Act. By the time she retired in 1972, she had overseen the filing of 300 equal pay lawsuits in 40 states, ultimately recovering millions of dollars for thousands of employees and earning the title of the nation's #1 fighter for equal pay for women. She traveled the country delivering more than a dozen speeches to labor lawyers and corporate counsel, almost always men, and many hostile to her cause. She urged them to comply with the Equal Pay Act and the new sex discrimination prohibition in Title VII, and she wielded her authoritative voice as an experienced and successful veteran of courtroom battles. One such battle was Schultz v. Wheaton Glass, perhaps Margolin's most significant appellate victory, which was not heard by the Supreme Court, which one commentator likened to a second Brown v. Board of Education. The New Jersey trial court had ruled that male selector packers in the glass factory were entitled to 10% higher pay, largely because they possessed so-called greater flexibility to perform additional duties. A decision that was feared to be reversal-proof despite its dubious merits because of the judge's extensive factual recitations informed by 2 judicial site visits, when even one is rare. Yet Margolin convinced the appeals court to reverse the trial court decision and establish that jobs need only be substantially equal, not identical, to require equal pay. The company petitioned the Supreme Court to take the case, as you may know, which is called cert, shorthand for certiorari. At Bessie's Gala retirement dinner, former labor solicitor Lawrence Silberman, today a senior federal judge for the D.C. Circuit, described what happened next.
As I told you, the Third Circuit, after argument, was terrorized into a decision which was, to say the least, sweeping in scope. I distinctly saw a footnote between the lines saying, "We'll give you anything you want. Please don't send her down again." And counsel for the other side petitioned for certiorari. And Bessie and I discussed it. Now, you can see the light in Bessie's eyes. She had a sweeping decision in the Third Circuit, but here was an opportunity to take an equal pay case to the Supreme Court. And Bessie suggested that maybe we should not oppose cert, because it would be appropriate to have the Supreme Court see this issue. Well, I didn't think there was any way in the world we were ever going to get a decision that was better than that Third Circuit decision. And I was by no means sure that the Supreme Court was going to be as terrorized as the Third Circuit. Although there are other speakers, there's another speaker this evening that can address that point. But I figured a way to deal with the problem. I just sort of leaned back in my chair and I said, "Bessie, you know, I've never argued a case in the Supreme Court." She said, "We'll oppose cert."
That was just one of the colorful stories Judge Silberman shared with Margolin's more than 200 guests that evening, a constellation of judges and government dignitaries. Supreme Court Chief Justice Earl Warren, then retired, was guest speaker. Here's an excerpt of Chief Justice Warren's tribute to Bessie Margolin.
That in the 33 years of litigation representing the Tennessee Valley Authority, the Labor Department, and implementing the Fair Labor Standards Act, she didn't always have a bed of roses. I am sure the hundreds of briefs that she wrote and the scores of cases she argued, some in every one of the 11 circuits and 27 in the Supreme Court, must have raised enough hackles in some quarters to have made her look forward to the serenity of retirement. The 27 cases alone that she argued in the Supreme Court was a prodigious undertaking. The Fair Labor Standards Act was not always popular in all quarters, and the flesh and sinews that were developed around its bare bones were her great contribution to millions of American working people. Many of these people do not know who Bessie Margolin is or what a great service she rendered to them. But if they did know, they would praise her tonight. In their name, I would like to thank her tonight because the bare bones of that act would have been wholly inadequate without the implementation that she gave in the courtroom, she forged in the courtroom of our land.
I'm not going to try to top the Chief Justice's remarks, so I'll add only a few concluding comments. Fair Labor Lawyer, the title of Margolin's biography, refers literally to the New Deal legislation that she shepherded through the courts. But it also refers to the fairness of Margolin's own career, the obstacles she faced as a woman, as a Jewish woman, the opportunities that influential supporters afforded her, her use of her feminine charms, and her passionate personal life, the one you'll need to read about in the book. But for me, the title also represents the challenge I've imposed on myself in doing justice in telling Bessie's remarkable story. I hope I've succeeded. I think Bessie would be particularly pleased to know that the Supreme Court Historical Society invited me to share her story. The court was a very special place for her. Here she is pictured in 1991 with her niece, Charlotte Margolin, dressed up and on their way to the Historical Society's gala dinner that evening. As for the book, I think Bessie would also be happy to know that her biography has received a fair share of positive published reviews. I'm sure none of them would please her as much as this unpublished and handwritten review, which is also one of my favorites, and I'll quote an excerpt. As daunting as the undertaking must have been, you have accomplished an important mission in bringing the work and days of a remarkable woman vividly to light. Although Bessie's path and mine never crossed, I had heard much about her. Thank you for enabling me and legions of other lawyers to appreciate what a front runner she was. And it's signed Ruth Bader Ginsberg. Thank you for your attention. Frances Perkins, in congratulating Bessie on her very first Supreme Court argument and victory, said that she was particularly pleased to learn how animated the court was and that it asked her so many questions, because Frances Perkins understood that that demonstrated the court's unusual interest and Bessie Margolin's intelligent presentation. So I hope you have lots of questions for me. Thank you. And I think we almost have Jim's audio.
Here we go.
There we go.
You have it? Do you have my audio now?
We do.
Okay, thank you, Marlene. Thank you so much, Marlene. What a wonderful presentation, and I love the way you wove into it excerpts from video and audio accounts as well. we're going to be taking questions from the audience now, and if you have questions, please type them into the Q&A section, and we will get to as many of those as possible. Your connection with Bessie Margolin is extended for many years. Tell us a little bit about that, and if you had, I know there's a story to tell about your admission to the Supreme Court bar.
Yeah, Bessie was quite a formidable person, and I guess in some ways I was lucky that I was a mere 18 when I first met her, because I would have been overwhelmed by her everything if I'd known more about her and known more about history in the Supreme Court. But she was just so gracious to me, but she was a formidable presence. I'm glad that I was not her employee or subordinate. There are stories of the exacting way she was about finding the precise word for briefs, no matter how late it required others to stay, about the secretary who left during lunchtime when Bessie took over because she just couldn't keep up. But with me, I think she saw perhaps a little of the same little girl from New Orleans that she was. And she was just always very dear to me. The story about my admission to the Supreme Court, it was 1993. I had known Bessie probably and was in touch with her regularly over about a dozen years, but I fell out of touch when my own career was underway and my family got started. But I needed to be admitted to the Supreme Court for some things I was working on in the Attorney General's office. And it dawned on me how wonderful it would be if not only to go in person, many may know that you can be admitted to the Supreme Court simply on written submissions, but it is such a historic thing to be admitted in front of the court. I reached out to Bessie to see if she would do me the honor of moving my admission, but she was infirm at the time and was already living in nursing care. So I went ahead and had a wonderful person from the Attorney General's office move my admission. But the beauty was, it was Ruth Bader Ginsburg's first day on the bench. And as many of you may know, she came out swinging. So fast forward to the writing of this article, and I was, as you mentioned, and as Chilton mentioned, I was honored with the award from the Historical Society for the article. And at the reception, there was Ruth Bader Ginsburg. And I had a chance, I was shoved up to the front of the crowded room to have her audience for a moment. And I was tongue-tied. It was, this celebrity of judicial stature. And all I could think to say was, Justice Ginsburg, I just want you to know that you made my day so exciting when I was admitted to the Supreme Court, because it was your first day on the bench. And as I was silently kicking myself for uttering such a silly thing, I decided I should pay attention, and the justice was speaking to me, and she said very sweetly, it was a very exciting day for me as well. And I had run out of questions at that point, too overwhelmed, and the next person was ready to speak with her. But so the final loop, the bookend, of course, was when she wrote the lovely handwritten note. And anyway, so that's my connection, making a connection between Bessie and Justice Ginsburg.
What a lovely memory. Tell us about your research on women who argued before the Supreme Court throughout history and your methodology. It's one of the questions that's come from our
I'll tell you, much like the way I wrote Bessie's biography as a reluctant biographer, I was a lawyer, as Chilton noted, I still am. And I didn't know the first thing about writing a biography. I tried to get others to do it, but it looked like I was the last one standing, and here we are today. So as I began to write about her, literally the first question I thought was, well, wait, she always said about herself that she argued that the one statistic that got repeated was she won, and I'll word it as it was often repeated, she won 25 of the 27 cases she argued at the Supreme Court. And I said, well, that's a very tangible place to start. Let me figure out what those cases are and what happened to the two. Well, that sent me spiraling into a rabbit's hole because it soon became clear there's a difference between counting cases, separately docketed cases, versus arguments. And so I ended up again with Claire Cushman's wonderful editorial assistance and her scholarship on women at the Supreme Court, proposing a methodology by which we could compare the records of historic Supreme Court advocates, and making sure that if someone stood at the podium for what was 3 or 2 separately docketed but consolidated cases, we call that one argument. So for purposes of comparison, it seems like angels dancing on the head of a pin, but it hadn't been done. And so I did that. And that was all part of the bigger question of, well, what number was Bessie at the Supreme Court? How many women had argued before her? And how, where does she stand in the pantheon of female advocates? And I was sure someone like Claire or other scholars had a list, and I would just look it up and that would be it. Well, no such luck. And that sent me down the research rabbit hole of literally counting every woman who had ever argued at the Supreme Court to identify that Bessie was the 25th. And then to try to figure out in the 20th century, had anyone argued more than her 24 times, which led to the list, which the Supreme Court Historical Society has very nicely put on its website. And because of some errors in counting and other things, it has been revised. And I'm told if it's not already there, you will soon see the brand new full list up to the end of arguments in October term 2020. And, I don't think this is too much of a spoiler, but I'll let you know that as of the last argument, April 28th, 2021, a total of 769 different women have presented a total of 1,555 arguments over the history of the court. And the thing that I think people always want to know, well, who's argued the most? That is Lisa Blatt. She continues to hold the record for the highest number of arguments by a woman at 41. And to this day, only 11 women have presented 20 or more arguments. As I mentioned in the remarks, Bessie is still one of only six women have topped Bessie's number of 24 arguments. So again, it needed to be done. I'm glad it's done, and we could probably have all sorts of philosophical debates about whether we should continue to use such a binary approach to the advocates. But until we at least assess and push women and encourage more female voices at the court, we'll probably have to deal with those devils in the detail for some time to come.
It's very important work, Marlene, and we're grateful that you spent so much time digging into it and getting it right. And
I'm just glad somebody's reading it.
a related question, did you come across any relationship with the other great woman Supreme Court lawyer of the era, Bessie Rosenberg, head of the Justice Department Criminal Division, Appellate Section?
Yes, Bessie and Bee knew each other, and because when Bee, in the last phase of her career, I believe, became essentially the enforcer at the Equal Employment Opportunity Commission when it finally got enforcement authority for Title VII. And so she and Bessie crossed paths in very important ways. And I understand compared notes and sort of schemed together to keep the law advancing. And there was a picture, as you may have noticed, of Bee at Bessie's retirement dinner. There was a photograph of 4 very able counsel all comparing notes and enjoying a conversation.
Do you have a theory on why Bessie isn't better known today? And I had the same question when I learned so much about B. Lockwood being the first African and a candidate for president in the 1800s, which it's not taught in the history books very frequently. But both are just sort of underappreciated, it seems to me.
Yes, and if, I will be very happy when Bessie continues to have more recognition for what is owed, as for many women. The interesting thing is, I'll take one example. For the history of the Tennessee Valley Authority, which in itself is such a wonderful and historic evolution of government agency and government being a part of services to people, there's an extensive oral history collection in Tennessee, and Bessie's not among them. I think there must be near 100 oral histories that were done. Now, I did not see anywhere the letters requesting interviews, so I don't know whether Bessie was asked or not. So she may not have ever been asked, although she's referenced quite generously by her distinguished counsel, who credit her, in fact, for materially shaping the briefs and all of her work there. But there is also the fact that Bessie was very private personally, and as I have alluded to not so subtly, had quite an active social life that tended, when it did become known, got her into trouble with both the FBI, which made its way to the White House in her name check for federal judgeship, and also got caught up in some congressional investigations because of her paramour, who was then the chair of the Federal Communications Commission. It could have been that if Bessie were asked, she may not have given the oral history, but I don't know that for a fact. There were lots of women in the rooms where important things were happening, but unless their oral histories were captured, or their papers were captured, or their points of view, or they were lucky enough, as Bessie was, to have champions, male for the most part, who enabled her to have her name on the brief, for her to get recognition at the time. Unless that happened, those lone and few women in the rooms where history was being made is lost. Which leads us to one of the lessons learned, which is how important it is today, as we go forward, to recoup these stories from people who were still around, or descendants who have those papers.
Well, we're very grateful to you, Marlene, for taking that on and doing such important work. It was such a thoughtful note from Justice Robert Jackson that you mentioned in your remarks. Can you describe further Ms. Margolin's relationship with Justice Jackson, if there are more details that you're aware of?
Yes, he certainly took note of her because, of course, he had his own government service, as in the Solicitor General's office before he became a justice. So he knew of Bessie from there. But what really cemented the relationship was the time they overlapped in Nuremberg, where she was able to see Justice Jackson, as the chief prosecutor for the United States, take on the historic prosecution of the top 24 Nazis in the single international trial. And she watched those trials. She wrote him a note when she heard his famous closing argument, as she was beginning her work to help figure out with Telford Taylor how the rest of the alleged Nazis were going to be brought to justice. And she wrote him a note and said that about his stirring argument, and that further cemented their relationship with his return to the bench and her continued practice for the Labor Department. And so there weren't a great number, but there were notes where he went out of his way to talk about how her note touched him the most, when she wrote him about a case called Tumaniello, a First Amendment case in which he took a not well-favored view, but at the time, Bessie and he took the same stance about how we had to be careful not to allow what had happened in Nazi Germany to happen in the United States. And so they shared a particular bond over that. It was always cordial, always very professional, and she had great respect for him.
Interesting. Why did she retire at such a young age? Was it an illness or?
No, it was politics in some regard. There are lots of reasons, but one in particular, Lawrence Silberman, for example, and the incoming solicitors of labor were younger in years than she had been employed at the Labor Department. And with the incoming politics, you know, she had started with the New Deal and was there with Kennedy and the Equal Pay Act and the visions for the future and Great Society with Lyndon Johnson. It was hard for a New Dealer to deal, in her words, with the Nixon administration. She lasted then, but thought that it was really time. And she also, I think, was looking forward to enjoying her time going forward, and ended up doing two of the things she always wanted. She didn't get a judgeship, but she became an arbiter, and she heard and tried labor cases. So that was as close as she came to being the judge. She also, too, had been rebuffed early on when she first was leaving Yale and was leaving Tulane to go to Yale. She had dreams of being a law professor, which, for those who know legal history, was an even more audacious goal than being a legal practitioner. She was rebuffed at the outset for that. And so she finally managed to get a position at GW Law School in DC, although short-lived, where she taught labor law. So she was able to do that and really enjoy time with her family and with the last great love of her life, another part of her passionate social life.
We have several other questions that have come in, but we only have time for one more, Marlene, and it's a tribute to how interesting your topic is. I'll pick the one to wrap up on, and that is if you know of any other particularly close relationships you may have had with other members of the Supreme Court.
Well, William O. Douglas, because of the close relationship and his admiration of her work when she was that doctoral student at Yale Law School, he was one of her thesis advisors and greatly influenced. She pursued. Her thesis ended up being on bankruptcy law, which William O. Douglas was very much in the throes of, the legal realism in dealing with the problems that the society was facing. And so she ended up arguing all of her 24 arguments while William O. Douglas was on the bench. He was instrumental. He wrote her a very important letter of endorsement for her federal judgeship. He offered his advice on what she should do with a sabbatical that she had won as a top prize from the Labor Department. And you may have seen him in the photograph, was seated right there at front and center at her retirement dinner. Her relationship with Abe Fortas, Justice Fortas, started also at Yale when he was there. They knew each other lifelong and through the New Deal defense. And he was important as well, but he did not use his formidable influence to help her with a judgeship. And they had just seemed to separate, or he did not endorse her in that way. And Justice Goldberg, of course, had been labor secretary during Bessie's time there, so she got to know him as well. I think those were probably right now come to mind as the most important, and all of them were at her retirement dinner. Another legal giant that was a dear friend was John Minor Wisdom, the Fifth Circuit judge. They were both at Newman School together. He was a little older than she was. She in fact was in the class with his brother, and the Judge Wisdom was just a year or more ahead. Judge Wisdom's brother Norton was in her law school class. But whenever someone from the Labor Department would end up before him in argument, he always asked for Miss Bessie and asked how she was doing. And he was at her retirement dinner. He was just not in any of the photographs I showed.
The courthouse in New Orleans is named for him.
Exactly.
Well, Marlene, this was so interesting, and we thank you very much for such an engaging conversation and discussion about Bessie Margolin. Fascinating. I want to remind the audience that that signed copies of her book, Fair Labor Lawyer, are still available at the Society's gift shop, and I'm holding up a copy of it right now for you to see. You can find it at www.supremecourtgifts.org. It's a very thoughtful read, and you can get more details of some of the stories that Marlene shared with us today. I also want to highlight that Marlene has done some amazing in-depth work on the women who have argued cases before the Supreme Court, as some of our questions brought out this afternoon. Her groundbreaking research is available on our Society's website. And finally, because this is a new format and experience for Society and our members, a survey will go out later this afternoon to everyone who registered in advance. And we encourage you to please respond. We want to make these programs as rich and accessible to as many people as possible. And as Chilton Varner mentioned at the outset of today's session, we want to continue these post-pandemic. We've enjoyed doing them very much. We hope you have as well. So for more information about the Society and our future events, please visit our website at www.supremecourthistory.org. And we look forward to engaging with you in future programs like this one. Thank you for joining us today. We are adjourned.